Oh, hello everyone. Welcome to another session of the GBX seminar. 今日好好啊，我哋喺 Ottawa 我哋嘅朋友 Amelia， 咁蔡律師，咁佢就同我哋分享呢個IP 呢個題目，我哋點樣可以用 intellectual property 去 enhance 我哋嘅 productivity。我哋加拿大其實就都好叻嘅，我哋好多發明㗎嚇，嗰啲 Blackberries 甚至以前嗰啲電話啊 Bell 啊好多Marconi 呢啲都係加拿大嘅innovation。咁加拿大好叻嘅。咁而家嚟講咧就 protect 我哋嘅 intellectual property 好重要。咁所以除咗話識得 Amelia 係呢個方面嘅工作咧，我都有其他朋友係做呢個工作嘅。咁呢個都好開嘅題目。咁我哋今日咧就有機會聽 Amelia 講呢一樣嘢。咁Amelia 會分享佢自己嘅一啲嘅內容啦。咁但係我就知道咧 Amelia 佢之前嘅 career 係 IT 嘅。咁亦都包括喺 IBM 做工。咁我喺 screen 度咧我都見到有幾位都係曾經都喺 IBM 做過工嘅嚇，我自己都係。咁亦都佢後來亦都讀咗 lawyer 呢個 subject 啦。咁佢嘅 specialization 係 intellectual property。咁我哋今日就會聽到好多嘅 information， 好多 example。我哋之後咧亦都會有一段時間係留翻嚟做 Q&A 嘅。咁到時咧就可以用 any language 都可以。Amelia 嘅 speech 咧就會用英文。咁我哋正式開始之前咧，我哋有個 disclaimer 嘅，咁我都想 show 一 show。因為Michael 同Winston 佢安排咗我哋呢個活動。咁我可能要做個 screen share， 好，咁就有個 disclaimer， 我 try to make it bigger， cannot see your application。睇唔睇到個 share screen 啊？大家
睇到
好我要 try to make it bigger。OK， 大家稍微望一望啊。呢個群組我哋嘅 seminar 係一個benefit program 嚟嘅，即係我哋係義務咁做嘅。咁所以有呢啲 disclaimer 喺度。呢個群組係交流信息，咁我哋唔會負任何責任啦。大家望一望啊。咁如果有興趣愛呢個 content 嘅話，我哋可以另外發俾你嘅，你可以再睇一睇。咁就without further ado， 咁我哋就將時間交俾Amelia。好 ，thank you。
Thank you, Stephen。見到啊？
見到。
Okay, good. Okay, so first of all, a special thanks to the GBX organizers, Michael and Winston, for inviting me to speak to you about the importance of IP protection. And thanks to Stephen for moderating tonight's session, and thanks to all of you for joining us tonight. So the presentation will be in English and followed by a Q&A to be conducted in English or Cantonese. In addition to the GBX disclaimer, here's also my standard disclaimer. So tonight's presentation, sharing, and Q&A are for educational purposes only and do not constitute legal advice, and no solicitor-client relationship is formed. If you have any specific legal questions or need assistance in any IP-related or legal matters, you're most welcome to contact me after the webinar. So today, I'll share with you about the importance of IP protection in this knowledge-based economy. The title of my presentation is The Race to Innovation, Protect Your IP and Be a Market Leader. I will first give a brief introduction about my intellectual property and business law firm, Choitech & Law Professional Corporation, which was recommended by the Canadian Trade Commissioner's Service as a preferred Canadian IP service provider. My firm has established strategic partnership with a strong global network of IP professionals, assisting our clients to secure and enforce their IP rights globally. My practice involves assisting both domestic and foreign clients in all IP-related legal matters in Canada, with a special focus on filing and prosecuting trademark, industrial design, and copyright applications, IP portfolio management, and providing strategic IP counseling, facilitating IP licensing deals and technology transfers, and IP transactions in a wide variety of industry sectors, and drafting contracts. On this slide are some of the services that we provide. We also conduct IP due diligence in M&A transactions. Relating to patents, we conduct prior art searches, freedom to operate, patent validity, and infringement opinion for our clients. We also advise on counterfeiting and enforcement issues. We represent our clients in IP-related disputes, assisting them with regulatory compliance and advising on marketing and advertising-related legal issues in Canada. My firm has assisted the Canadian Trade Commissioner Service and has been providing IP support and legal advice for Canadian SMEs that are interested in entering the market in China. Not only do we assist the Canadian SMEs, but we also assist businesses from other parts of the world to register and protect their IP assets in Canada. And here are the topics that I'd like to talk about today. I will first start with a few words about innovation and IP. Then I will provide you with an overview of the types of IP in Canada. If time permits, I may talk about a couple of trademark cases, and then I will show you some numbers to give you an appreciation of the global IP trend, bringing home the importance of protecting your IP. And I'll close the presentation with some immediate actions that you can take. First, innovation and IP. Ideas and brands that are transformed into invaluable assets through the use of intellectual property rights or IP rights are critical sources of value in the global innovation economy, not just for cutting-edge science and technology, but also for day-to-day consumer products and services. In the most recent intangible asset market value study, intangible assets, which include IP rights, now account for 90% of the S&P 500 market value in 2020. While IP rights continue to play an important role in protecting tangible products from being initiated or from being imitated and copied by competitors, they are increasingly leveraged as assets in their own right through strategies based on revenue-focused licensing. Companies use their large IP arsenals to deny freedom to operate to competitors, effectively keeping them out of the particular markets. In simple terms, IP is like a fence to your house. It sets a boundary of your property, and anyone who enters into the boundary of your property is liable for trespassing. IP defines the scope of protection of your intangible assets, which includes your inventions, embodiments of your ideas, brands of your products and services, designs, artistic expressions, and know-hows. IP owners exercise exclusive rights, which keep others out from appropriating IP owners' rights without their prior authorization. Any act that interferes with the full enjoyment of the monopoly granted to an IP owner is liable for IP infringement. IP can also be used as a sword by the IP owners to go after those who infringe on their rights and to seek legal remedies such as injunctions, damages, or accounting of profits. It is not sufficient to merely protect your IP through registrations and contractual agreements, but IP owners should also actively monitor and enforce their IP rights. This is particularly important and challenging, especially in the internet and mobile era, and more recently in the metaverse. Most types of IP are jurisdiction-based. And what that means is that they are effective only in the country or region where the IP registration is obtained. IP can also be used as a shield. It serves as a bargaining chip on the negotiation table and in settlement discussions when you are being sued by others for infringement. It will enable you to explore options such as cross-licensing and may deter lawsuits. Not only can IP owners use their IP assets in their products and services to attain market leadership in their fields, they can also leverage their IP assets to generate extra revenue for the company, such as through licensing out and assigning their IPs that may not be essential to their core products and services. When you devote a significant part of your time, effort, money, and skills in R&D, in marketing and building your brand, in endeavoring in creative and innovative work, whether they be simple improvements or disruptive science and technology, no doubt you would want to give them due protection to leapfrog competition. Focus on the core strengths of your business and achieve market leadership in order to thrive and to compete in this global economy. As I've said, certain types of IP like patents and trademarks are jurisdiction-based. For example, if you have patent registered in Canada, you're given exclusive rights and protection only within Canada and not anywhere else. Likewise, if you have your trademark registered in Canada, it does not mean that you're free to use the same mark in other countries. It is very important for all businesses to consider upfront to align their global IP strategy in support of their overall business strategy. On the slide are some questions that you may consider. After identifying the markets where you want to protect your IPs, talk to an IP lawyer to advise you on various IP filing strategies and the cost and time associated with each option. For example, in the case of trademarks, does the target jurisdiction adopt a first-to-file or first-to-use system? Do I file my trademark applications directly in the target jurisdiction, or do I file using Madrid Protocol? What are the pros and cons, and what are the time and costs associated with each option? Is the target jurisdiction a contracting party to these treaties? What are the other options that I should consider to maximize the term of protection in that jurisdiction? When it comes to registering your IPs, time is of essence. In some cases, you may even lose your entitlement to register your IP in certain jurisdictions if you miss the window of opportunity. If China is one of your major target markets, then you must seriously consider registering your IPs in China before entering into that market. You may also consider conducting a freedom to operate search in case of a patent, or conducting a trademark search before you export your goods or services to China to avoid infringing on others' registered IP rights. It is very important for all businesses to consider their global IP strategy upfront, to align with and to support their overall business strategy. IP strategy cannot be an afterthought. Now, the key is to ensure that no product names, images, or confidential information are disclosed before your non-disclosure agreements are signed and before your IP lawyer has a chance to complete the necessary IP application filings and to have all the relevant contracts reviewed. These are the major types of IP in Canada, and we'll briefly take a look at each of them. Patent. A patent protects new, useful, and non-obvious inventions and their improvements. For the invention to be considered new in Canada, there must be no patent application that has been filed by others for the same invention before the filing date of your patent application in Canada. Therefore, file as early as possible before any disclosure of your invention. A patent gives exclusive right to the patent owner to exclude others from making, using, or selling the invention in Canada for up to 20 years from the filing date of the patent application. So anyone who makes, uses, or sells a patented invention anywhere in Canada without the patentee's prior authorization during the patent term infringes on the patentee's rights. Trademark. In addition to letters, words, or logos, Canada now also supports new types of traditional trademark or non-traditional trademarks, such as scent or smell, texture, taste, hologram, moving images, sound, and color. So you can use any of them or a combination of them as a trademark. A trademark must be capable of distinguishing the source of the goods and services. It ensures consistency and quality of the goods and services used in association with the trademark to protect consumers and businesses. It protects your brand's value and goodwill in the marketplace and protects against misappropriation and unfair competition. There's a difference between a registered trademark versus an unregistered, or sometimes they call it common law trademark in Canada. An owner of a registered trademark is given the exclusive right to use a registered trademark for the list of goods and services that are included in the registration across entire Canada. But an unregistered trademark doesn't. The other advantage of a registered trademark is that in the event of a trademark dispute, the unregistered trademark owner will have to spend a lot of time and money just to prove its ownership and use of the unregistered trademark in a specific locality. Whereas to a registered Canadian trademark, the trademark registration itself is prima facie evidence of trademark ownership. The owner of a registered trademark can enjoin others' use of a trademark that is confusingly similar to his registered trademark. The term of protection for a registered trademark is 10 years from the trademark registration date and can be renewed every 10 years thereafter. Canada is based on a first-to-use system. Use of a trademark in Canada will remain the key factor for determining the seniority of rights to a mark in the event of a trademark dispute. Now, some countries, such as China, are based on a first-to-file system for obtaining or registering their trademark rights. The first applicant who files a trademark application will be able to preempt all other later applications for the same or similar trademark in respect of identical or similar goods and services from registration. That's called the first-to-use system, first-to-file system. So therefore, it is very important that you file your trademark applications at the soonest time possible to preserve your rights. A trademark, once registered, is subject to something called Section 45 expungement or cancellation proceeding that is based on non-use after 3 years of registration. So if you plan to file a trademark application in Canada, or have a pending trademark application in Canada, or plan to use a specific trademark in Canada, and you find the existence of another similar trademark that has already been registered in Canada by somebody else, that may disentitle you from successfully getting your trademark registered in Canada. And in which case, you may consider commencing a Section 45 expungement proceeding to cancel the other party's trademark, assuming that there's no use within the last 3 years. It is very important that you actively monitor the market, the various social media platforms, the internet, the trademarks registry, and even metaverse, to see if others infringe on your trademarks and take prompt action to enforce your rights in order to prevent dilution of your trademark or depreciation of goodwill of your trademark. Some cost-effective ways of preventing others from registering their trademarks, especially if they are confusingly similar to your trademarks, include filing a notification of third-party rights with the Trademarks Office anytime before the registration of that mark. Another option is to start a trademarks opposition proceeding within 2 months of the advertisement of that trademark application. So if someone infringes your registered trademark, you may commence a civil action before the court. There's also the option of customs recordal, and that's only available for registered Canadian trademark and not to unregistered trademark. It's also available for a valid Canadian copyright as well. So basically, you file a request for assistance form with the customs, the Canadian Border Services Agency, and they will monitor if there are any counterfeits or pirated copies. And at that point in time, they will then notify the IP rights or the trademark's owner. Then the trademark's owner will have the option of commencing a court proceedings accordingly. Next is industrial design, which is another type of IP.
Amelia, sorry, excuse me. 你嗰個而家嗰個 presentation 咧出嚟個 screen 咧唔係個 full screen 嚟嘅，你睇下我哋可唔可以改嗰個 full screen？ 有啲人係睇得唔好，用手機睇嘅話睇得唔好清楚。
Oh, really?
Yeah.
It's full screen here. 你哋其他人有冇can you see it full screen?
No, you can speaker screen.
Huh?
Your speaker or mode. You are using the speaker mode so that you can see the notes, okay? But what you see is what we see.
No, what do you see right now?
Are you seeing a full screen?
Yeah.
But you do have the footnote too, you know that?
Oh, really?
Yeah.
Show your footnote.
Okay. I don't know why that is. So let me try this. Oops. Hold on, escape. If I do that, okay, so let me, if I stop screen.
Try it again. Yeah.
Try again. Yeah, that's it.
Is it full screen now?
No.
Not yet.
Display. There's a button at the bottom. No, that's not this one. This is speaker mode.
Yeah, I'm wondering why.
Your previous mode is better because your title is all on the left-hand side. Right now, your title is on the right-hand side, which occupies 1/3 of the screen space.
Oh, really?
Yep.
Because this is speaker mode, okay? This is what you try to speak, you know, you look at while you're speaking. So you can see the next slide and everything. And I can see the notes, okay, for example.
So how can I pause the speaker?
Go back to the previous one. Go back to the previous mode.
Go back.
Yeah. Your previous mode is a little bit better because your titles are a little bit, yes, this is a little bit better. Let's keep it that way. I think we
No, Michael.
At the bottom of your screen right now, you do have a button, okay, with a slide, pointing downwards. You know the second icon, the first icon from the right. After the what? After the voice, you know, the volume control. You use that button. Do you see that button, the icon at the bottom of your screen?
Actually, right now there's nothing. It's a different screen.
No, I mean you do have a volume control, right? Do you see the volume control?
Right now, I don't.
You don't see your volume control, okay, in your screen?
No, I don't.
Oh, that.
啊
Because-
Amelia，如果你 exit 嗰個full screen mode 咧，你就會睇到嗰個下低嗰個 volume control。你先咧就 exit 個 full screen
我
mode。
而家先 stop 啊 ，pause 個 share 好冇 ？pause share。
哦，
Stop share here. OK， 我而家 stop share 啦。
嗯
OK, so I won't do the animation then. How about that?
you don't do the animation, then forget it. It's better than the speaker mode.
Yeah. OK. What do you see right now? What do you see right now on your screen?
The slides on the
your
right and
presentation.
Did you see the slide?
and the page on the left hand side.
OK. So it's on
Yeah.
slide 20, right?
Okay, yeah, it's better now.
It's interesting. How come you will see this notes? I'm just wondering why. Okay, that's
Because
that's,
there is a USB center
Speaker mode.
just
okay,
like
on the top of the screen in the middle, there is a USB center wheel. You can unclick it.
I don't have that.
Okay.
Yeah, you click it, you use presenter mode view and then click it and then it will come up.
I don't have presenter mode. I don't have anything called presenter mode.
Presenter view.
Industrial design. So next is industrial design. Industrial design protects the features of a product that appeal to the eyes. It protects visual features of a shape, configuration, pattern, or ornament applied to a finished product. It only protects the appearance of the product. It requires substantial originality and not substantially similar to other industrial designs that are existing out there. Okay. The term of protection for industrial design is 10 years from the date of registration, subject to the payments of a maintenance fee prior to the expiry of the first 5 years. A registered industrial design gives the owner the exclusive right to make, import, sell, rent, offer for sale any article bearing the registered design or design that does not differ substantially from the registered design. There is no marking requirement for industrial design, but there is a so-called innocent infringer defense, where only injunction is available if a registered industrial design without proper marking is infringed. Other remedies such as claim for damages or profits, punitive damages, disposal of infringing article may be available only if the industrial design is properly marked. Next one is about trade secret, because not all subject matters are patentable. So in that case, you may consider keeping them as a trade secret. To be considered as a trade secret, you must take steps to ensure its confidentiality. And these trade secrets must have economic value and is actually or potentially usable in business or trade. Unlike patents, trade secret protection continues indefinitely so long as they are kept secret and the protection is not limited territorially. However, you cannot prevent others who in good faith invented the same thing as your trade secret. Trade secret may be particularly appropriate in certain situations, such as when the subject matter is not patentable or when the value of the information is in its immediate exploitation and commercial value of the secret may be lost while waiting for a patent to issue. In Canada, we don't have a legislation governing trade secrets. However, you would have legal remedies only if someone misappropriate your trade secrets under breach of confidentiality or breach of non-disclosure agreements or breach of fiduciary duty. This is particularly true in the context of employment. So it is very important to have confidentiality agreements put in place. Did I say, yeah, so that's for employment. So you have to educate your employees as to what falls under the scope of trade secret and how to properly handle trade secrets. Next is copyright. The objective of Copyright Act is to strike a balance between promoting the public interest in the encouragement and dissemination of works of the arts and the intellect, and obtaining a just reward for the author. Copyright protects original expression of ideas, but not the ideas in and of themselves. An original work is the expression of an idea through an exercise of skill and judgment. Copyright protects literary work, artistic work, musical work, or dramatic work, and performances, sound recordings, and communication signals. The term of copyright protection in Canada is up till 50 years following the death of the author, after which it'll become part of the public domain. Although under the Berne Convention, works are protected by the facts of their creation, copyright registration is not a prerequisite for advancing a copyright infringement claim. However, the process for obtaining copyright registration is relatively simple and inexpensive, and the registration provides prima facie proof of evidence of the subsistence and ownership of the copyright. Moreover, a copyright registration obtained prior to proven infringement is beneficial insofar as it precludes a defendant from relying on a defense that it was not aware of and had no reasonable ground for suspecting that copyright subsisted in the artistic work at issue. Such a defense is expressly provided under our Copyright Act, and where applicable, entitles a plaintiff from obtaining any monetary remedy other than an injunction. So it is always good to have your copyright registered in Canada. One thing to note is that copyright ownership can be transferred or assigned to another person, but not moral right that is associated with the work. So what is moral right? Moral right allows the author of the work to require others to attribute the work to him, and it protects the integrity of the work for the duration of the copyright term. Moral right always belongs to the author for the term of the copyright. It can only be waived by the author of the work, but it cannot be assigned or transferred. Moral right is infringed if the work is modified or distorted or used to the prejudice of the honor or reputation of the author. So be careful. Copyright infringement consists of the unauthorized taking of the original work. Now, whenever there's copyright infringement, you can of course take it to the court, or you can also pursue customs enforcement by recording something called a request for assistance with the Canadian Border Services Agency, similar to that of the registered trademarks. Now, there are some exceptions to copyright infringements. And for example, we have something called fair dealing, and in US it's called fair use. And those are those that are done for the purpose of research, private studies, education, news reporting, and things like that. And some other exceptions also include non-commercial user-generated content, reproduction for private purposes, time shifting, like fixing signals and recording your TV programs for later listening or viewing, and backup copies. And with respect to the internet service provider, if there's any copyright infringement, in Canada, we have a notice and notice regime where a copyright owner can send a notice of claim infringement to the ISP or the internet search engine provider. The ISP provider will then forward the notice electronically as soon as possible to the subscriber identified by the electronic location specified on a notice and to inform the claimant of its forwarding. Next, we have domain name. So in Canada, we have the CIRA, or the Canadian Internet Registration Authority, that has its own domain name dispute resolution policy. So a complainant may lodge a complaint with CIRA to recover a .ca domain name that is registered in bad faith if it can establish prior rights in and to a mark with which the domain name is confusingly similar. The trademark registration obtained by a complainant prior to the date of registration of the domain name may readily serve to establish such prior rights. So this is another good reason for you to register your trademark early. There are other types of IP that I did not include on the slide, such as geographical indications, which identify a wine or spirit or agricultural product or food as originating in a territory or a region. And if the quality, reputation, or other characteristic of that product is essentially attributable to that geographical origin, we have something like, for example, here in Canada, Ontario ice wine, for example, and Champagne for sparkling wine. So those are considered geographical indications. And for geographical indications, you can also register that under the Trademarks Act. Next, we also have something called the Plant Breeders' Rights Act, which is administered by the Canadian Food Inspection Agency that allow plant breeders to protect new plant varieties. Today, we can see the multifarious applications resulting from this disruptive technology, connecting the world together in lightning speed, enabling trade without boundaries, bringing the world closer. With internet, it enables small businesses to leverage technology to compete with the incumbent and large companies. It enables small businesses to do global trade no matter where you are physically located. People are brought closer together, irrespective of physical distance and different time zones. During the Singles Day sales in 2021, that one-day sale alone exceeded a total of $139 billion, which is more than the sales in that's in China. And that alone is more than the sales in South Korea for the entire year in 2021. And it is also more than the e-commerce sales in France and Canada combined for the entire year. In step with the convenience and advantages that internet and mobile era brings us, we should also take steps to protect our IPs. Counterfeiting and IP infringement make easy with e-commerce and different forms of online social media platforms. Social media sites use social messaging apps for commercial use. They allow social media users to buy and sell through private messages. E-commerce through messaging apps like WeChat, Facebook, that takes away the opportunity for brand owners to see and monitor transactions in a public place. So the first thing that you need to do before you set up your online store is to register your trademark. IP strategy cannot be an afterthought. Securing IP is a time-sensitive matter. In the case of patents, you may be precluded from obtaining patent rights once your invention is disclosed to the public. Likewise, it is also too late if others registered the IP, such as trademarks, ahead of you. I'd like to say a few words about branding in the metaverse. As we know, Facebook has recently rebranded itself to Meta, placing significant interest in metaverse. Metaverse is a virtual environment that parallels the real world where users can interact with each other within a digital universe. and increasingly with brands. And in right now, actually, there are brand owners, for example, like the Louis Vuitton, that has been actively engaging with consumers in the metaverse through online games and selling exclusive virtual clothing lines using NFTs. An example is Gucci, that has collaborated with the popular online game Roblox to provide players with a chance to win a limited digital version of the Gucci bag. And the digital version of the bag was resold on the Roblox marketplace at a price even higher than that for an authentic physical Gucci bag. So as you see, Metaverse poses new opportunities for brand owners to extend their engagement with consumers and promote their brands in the virtual world. However, trademark infringement and counterfeits will also inevitably follow. Therefore, some forward-looking brand owners such as Nike, Converse, Abercrombie have already taken steps to file trademark applications for their goods and services relating to the metaverse, including downloadable virtual goods for use in online virtual worlds, retail stores featuring virtual goods, and providing digital collectible services. People are willing to pay for the brand. These are the world's most valuable brands in 2021. We know that the same article made in China, for example, when sold under a local brand may only worth $10, but when you put on a foreign brand, it may worth so much more. And that's the power of the brand. So you have to take measures to build and protect your brand. In Canada, we have some major changes in our IP laws, including our patent, trademarks, and industrial design legislations over the last couple of years. Today, I'd like to quickly focus our attention on a specific change to the Canadian trademark legislation to highlight reason why you want to file your trademark ASAP in Canada. And that is the implementation of Madrid Protocol in Canada, where a trademark applicant can file a Madrid Protocol application based on a Canadian trademark registration or a Canadian trademark application. In the past, a trademark applicant must specify when he has first used a trademark in association with the goods and or services at the time of filing a trademark application. Or if he has not started using the trademark, but intended to use a trademark in Canada, he has to file something called a declaration of use, stating that it has already started using the trademark after the application has been examined and allowed by the Trademarks Office before the trademark registration can be issued. This filing of a declaration of use is no longer a requirement under the new law, and is really based on the good faith and honesty system of the trademark applicant. This may open the door to potential trademark squatters, those that apply trademarks in Canada in order to hold them for ransom and sell at much greater price. A more prevalent issue arises from entities that register trademarks for a much wider range of goods and services than they actually use or reasonably intend to use, sometimes as a deliberate strategy to create obstacles for competitors. Put it simply, if you have been using a specific trademark and have not yet registered your trademark in Canada, register it right away. Otherwise, if a Canadian business has been operating in Canada for years and did not register its trademark, a foreign company that is located in a country that is also a contracting party to the Madrid Protocol would be able to file an international trademark registration based on their domestic trademark registration in order to obtain their trademark, to have their trademark registered in Canada. The Canadian Trademark Office may not be aware of the trademark that you've been using for your business in Canada all throughout these years because your mark is not registered. Therefore, the foreign business entity will be granted trademark registration in Canada. without your even knowing it, unless you've been subscribed to some trademark watch services that your IP lawyer provides. Trademark cyber squatting may then become an issue. Even though Canada is a country that is based on first to use instead of a first file system, the Canadian businesses will still need to commence an administrative or judicial proceeding to challenge the foreign entity's trademark applications or to expunge their registered trademarks in Canada, which means incurring unnecessary cost, time, and effort on your part. There's also a chance that you may lose your trademarks right, wasting all of the investments that you have put in over the years to establish your brand. There's also a possibility that the other party may sue you for infringing their registered Canadian trademark. Therefore, I strongly recommend that you take action immediately if you still haven't had your trademarks registered. So review your trademark portfolios now with a view to filing defensive trademark applications for unregistered marks in order to preempt trademark trolls, bad faith applications, and others international trademark applications. Now let's quickly, I think I'll skip over the trademark cases because of the time. What time is it right now? 9:54. So I would just take a look on the global IP trend. Despite the COVID-19 pandemic, Asian economies lead a worldwide bounce back to a 1.6% growth in patent applications, amounting to 3.3 patent applications in 2020. Now, all these data comes from WIPO, the World Intellectual Property Office, and they were published in the latest version, which is 2021. The data that they have is up until the year 2020. The substantial rise in filings by China, Republic of Korea, Hong Kong, and India are the main drivers of this growth in 2020 over the year 2019. Offices located in Asia received 2/3 of all patent application filings worldwide in 2020. This is an increase from the 51.5% in 2010 and is primarily driven by a strong long-term growth in patent filings in the China Intellectual Property Administration, or CINIPA, which in 2020 alone accounted for 68.6% of all patent applications filed in Asia. And CINIPA, or the Chinese Intellectual Property Administration, received 1.5 patent applications. That is equivalent to 45.7% of world total in 2020. This is 2.5 times more than the number of patent applications received by the US Patent and Trademark Office. This one shows the ranking of the total patent filings by origin in the year 2020. These are the top patent application filers by originating country in 2020, and they are China, US, Japan, Republic of Korea, and Germany. 90% of these received applications at the Chinese Intellectual Property Administration were originated from within China, meaning it's filed by the residents in China, or sometimes we call it resident patent filings. China ranked first in resident patent filings, while US and Japan ranked second and third respectively in the world. Canada ranked number 14. Now on filings abroad, which is an indication of a desire to expand in new markets, US-based applicants filed the most number of patent applications abroad. 48.6% of the total patent applications originating from US-based applicants were filed abroad, and from these that were filed abroad, 52% were filed in Canada. 46.3% of the total patent applications originating from Japan-based applicants that were filed abroad were mostly filed in Germany, Indonesia, and China. And 59.4% of the total patent applications originating from Germany-based applicants that were filed abroad were mostly filed in France, and only 6.7% of the total patent applications originating from mainland China-based applicants were filed outside of mainland China. And for those that were filed outside of mainland, they were mostly filed in Hong Kong and in Italy. On this slide, there were 1.6 million patents granted in 2020. The 5 biggest IP offices, or what's called the IP 5 offices, include that of China, US, Japan, South Korea, and EPO, or the European Patent Office. They accounted for 81% of the total patents granted in the world. Asia's IP office's share of worldwide patent grants is 58.1% in 2020. Patents enforced worldwide grew by 5.9% to reach around 15.9 million in 2020 across 135 jurisdictions. 21% of the world's total patent enforced are in US, 90% are in mainland China. It should be mentioned that more than half of all patents enforced in USA originated from non-resident applicants, meaning non-US based applicants, while only 25.5% of all patents enforced in mainland China originated from abroad, which means that most of all the patents enforced in the mainland China originated from within mainland. Again, China has the fastest growth in patents enforced in 2020, with its growth rate of 14.5% compared to the year before. These top 5 countries accounted for 78.7% of all PCT applications filed in 2020. PCT is the Patent Cooperation Treaty, wherein you can file one international patent application, and then on average, you can decide that, and you can then designate all the various contracting parties to the PCT treaty. Then after 30 months or 30 to 31 months after you file the PCT application, you can then decide to enter national phase on the specific countries, and then it will be prosecuted and examined according to the local laws. So it doesn't mean that you have an international patent that is good everywhere, but just that it's a way for you to file one international patent application, and then you have 30 to 31 months for you to decide which country that you want to enter into national phase, and then it will be examined accordingly. So some countries may approve and allow and issue or grant your patent, others may or may not. Okay, now these top 5 countries accounted for 78.7% of all the PCT applications filed in 2020. 25% of PCT international applications were filed by applicants based in China in 2020, compared to only 21.5% that were filed by applicants based in US. Applicants in Asia accounted for 53.7% of the world's total PCT applications filed that year. And here are the top PCT applicants in 2020. Huawei has been the top PCT applicant for a number of years. It's also worth mentioning that half of the top 10 universities that filed the most number of PCT applications in 2020 were from China. And the top PCT geographical clusters that accounted for the majority of PCT patent filings between 2015 and 2019 are also listed on the top right corner of the slide. Asia has also become the region from which the most PCT national phase entries are initiated worldwide, accounting for 35.6% of all the national phase entries in 2019. Next is on trademark. So in 2020, we have around 13.4 million trademark applications covering 17.2 classes that were filed worldwide. Now, for trademark applications, like for example in Canada, in each application you can actually file the trademark and together with a list of goods and services that were classified in accordance to NIS classification. So you could have multiple classes in one trademark application. Despite a considerable downtime or downturn in the economic activity during the COVID-19 pandemic, trademark filing activity actually grew substantially. And CINEPA, or the Chinese Intellectual Property Office alone, has a class count of 9.3 million out of the 17.2 million that we have worldwide. IP offices located in Asia accounted for 71.8% of all trademark filing activities in 2020, and that's up from 41.3%. And again, the Chinese Intellectual Property Administration accounted for 73.1% of the annual increase in global trademark filings in 2020. Trademark applications are filed mainly by residents seeking protection within their domestic jurisdiction. In 2020, residents filing at their respective home or regional IP offices accounted for 86.1% of global filing, with the remaining 13.9% associated with non-resident filings. IP offices receiving the most number of non-resident filings include Canada, Switzerland, Australia, US, and UK. On the other hand, only 2.5% of the total trademark filings received by the Chinese Intellectual Property Administration were filed by non-residents. So when looking at the non-resident filings, it's an indicator that those non-residents seeking to expand the market to those regions basically consider factors such as the relative appeal of those foreign markets for selling their goods and services, geographical proximity to those markets, and the existence of well-established historical ties between the trademark applicant's country of residence and the destination country. In 2020, 22.5% of all non-resident filing in China came from US applicants, followed by 12.7% from Japan and 10.5% from UK. Applicants from USA were the most active foreign filers in Brazil, China, and India. And in 2020, applicants from China accounted for the largest share of non-resident trademark filings at the USPTO. There are 64.4 million active trademark registrations worldwide in 2020, and that's up 11.2% from 2019, with 20.2 million active trademark registration in China alone, followed by 2.6 million in US and 2.4 million in India. So as you can see, there are many active trademark registrations in China. Next is industrial design. There are 1.1 million industrial design applications containing 1.4 million designs that were filed in 2020. Applications have more than doubled during the period between 2006 and 2014, and that's primarily due to the rapid growth in the number of industrial design applications filed in China. China received 55.5% of all designs contained in applications filed worldwide, and offices located in Asia accounted for 70.9% of all industrial design applications filed worldwide in 2020, and that's up to 60.8% in 2010. The total number of industrial design registrations in force worldwide grew by 11% in 2020 to reach around 4.8 million. The largest number of registrations in force is in China, with 2.2 million registered designs, representing 46% of the world total in 2020. So from these charts, China is not only a huge market, but it is also becoming an IP powerhouse. So if you plan to expand into that market, consider your IP strategy carefully. Do your homework and make sure that you're not infringing on others' IP rights. If the IP search is clear, then you're free to operate in China or in whichever country that you plan to enter in. Make sure that you have the IP rights registered there before others file ahead of you. Now, this is the Global Innovation Index 2021. WIPO released this index that captures the innovation ecosystem performance of 132 economies, and it tracks the most recent global innovation trends based on around 80 indicators like R&D investments, political environment, education, infrastructure, business sophistication, innovation outputs, and knowledge creation of each economy. The ones marked in green has improved its ranking compared to the previous year, and the ones marked in red went down in ranking compared to the year before. And the ones in gray maintained their ranking from 2020. As you can see, China went from actually number 14 in 2020 to number 12 in 2021. And to give you some context, China rose from number 54 to the 46 between the years 2004 and 2009. And in 2019, it climbed from the 17th to the 14th in the global ranking in respect of global innovation. And now in 2021, it climbed further to number 12. So again, very, very rapid development. And Canada also rose in its ranking in 2021 to number 16. And to recap, in this internet era, you cannot have the narrow vision and consider doing business only domestically. You need to think global. And kudos to the founders of the platform, the Global Business Exchange, GBX, who helps GBX members to think global and facilitate global businesses and trades. Even though some people may not be exporting their goods and services elsewhere outside of Canada at the moment, but eventually all will in order to survive and thrive. Therefore, consider your IP strategy alongside your business strategy. File your IP applications and secure your IP rights early. Talk to your IP lawyer to have a good IP strategy in place. Not only do you need to protect your IP assets, but also need to continuously monitor the marketplace and enforce your IP rights. Don't let your secured IP rights become dormant. Instead, commercialize your IPs to generate extra revenue or leverage your IP assets to strengthen your market leadership. Review your trademark portfolio to ensure that your trademarks are registered. Moreover, Canada applies a very strict rule requiring detailed statements of goods and services in your trademark registration. But counterfeit goods usually bear known brands and logos on goods not included in trademark registration. Therefore, you should consider amending your trademark registration so that infringement will apply to any goods bearing confusing trademarks, whether or not a registration includes the specific goods. And finally, take action and act promptly. Not only do you need to do your IP filings, but you must do it fast or you may forfeit your rights or others may get ahead of you. And thank you. That's the end of my presentation.
Thank you very much, Amelia. Thank you.
Thank you. Sorry for the technical problem a while ago.
Yeah, thank you for a very clearly delivered presentation. It's very easy to follow and very easy to understand. So, of course, the importance of protecting IP. Otherwise, all the work will be wasted. So yeah. We are coming to the Q&A session. You can ask the question in any way, any language you like. Okay, so now if we have a lot of questions, we do need to see your hands or you wave to us, and then I will call out your name, then you ask your question. But we don't have a lot of hands yet, then you just say it, you just unmute yourself and maybe bring the question up. If there is a traffic jam, then the moderator, me, will try to help. Otherwise, you are quite free to ask the questions and add more insight for everybody to learn more. And especially, we can ask Amelia some general questions. Okay. For specific questions, though, because of privacy, you are welcome to contact Amelia offline. Okay. So anybody want to throw in the first questions?
I think Jack has a question.
I saw a comment, a question on the chat box. It's by Jack, I think. Yeah. So yeah, there's a lot of information on the internet that you can take a look at. There's a CIPO website, or the Canadian Intellectual Property Office. You can Google it. It has some IP resources that provide you with some general information about what the IP, different types of IP we have in Canada. We even, at one point, a few years ago, I was invited by CIPO, or the Canadian Intellectual Property Office, to help them in putting together some presentation and resources in terms of protecting IP rights in China. And now they have a few of them that were compiled that are readily available online. IP protection in China, in US, and some of the other major jurisdictions. So you can look that up online for sure.
Thank you. Desmond.
Hey, Amelia, it's Desmond here.
Hi, Desmond. Maybe
Thanks for your time. Yeah.
Sorry, can we do the screen where we can see everyone instead of myself?
I am looking at everyone. It is your own selection. You can go to the gallery mode.
Yeah. Okay. All right. Good.
Yeah.
Yeah. Hi, Amelia. Thank you for your time.
Hi, Desmond.
Yeah. That was a great presentation. I really appreciate it.
Thank you.
Yeah. Hey, I just have a quick question. Like, how efficient is China enforcing the IP law?
Okay.
Yeah.
This is a very good question. And this is what I always tell people, because a lot of people don't know about it, because especially here in the West, a lot of people are saying that China has very poor IP enforcement system and things like that. But what I want to tell you is that the central government, China, has done a lot over the last few years. And they have many legislative changes. Like in Canada, for example, it takes us decades for our laws to get changed. But in China, you really have to keep up. Every 3 months, you have to take a closer look at it. So, for example, in China right now, they have amended their Trademarks Act, their trademark law, patent law. They also have unfair competition law, and in terms of enforcement, they are actually doing very well. In China, they have if there's any infringement, you basically have 3 routes to pursue after the infringers. One is through the administrative route, and the other one is through judicial, and then the third one is through customs enforcement. And and also over the years, China has also established something called specialized IP courts, which we don't have here. Okay, and those are very good, because then you have the same set of judges who are looking at these patents and trademark cases every day, and they built up the expertise. Now, as we know, China is a civil law jurisdiction, as opposed to Canada, where common law, right? But even though China is under civil law jurisdiction, in terms of IP, I can say that with respect to IP, the courts also publish their decisions, and there are precedents that are quite persuasive. So it's there's certainty in terms of the rulings. And in fact, in 2016, for example, I remember, because like there are some concerns about some foreigners who said that, okay, there may be favoritism and whatnot, and there's no fairness in terms of the judgments, etc., etc. But back in 2016, I think it's almost 100% that of cases were ruled in favor of foreigners. Now it's still at around 80 to 90%. So it's a very good percentage. And I would say that the judges there are very knowledgeable. In summary, I would say Chinese enforcement system is very good, and even their customs enforcement is very good. Actually much better than us. They also have the administrative route wherein they can actually raid the factories and then, and collect all the evidences and destroy those infringing goods. So it's excellent. Now, of course, there's still a lot of counterfeit issues and cases, right? But we have to put things into perspective. China is 1.4 billion people, right? So yes, there are a lot of, there's still many bad actors, and there are even bad faith trademark filers, like people who file trademarks without the intent of using it, but just to use it as a ransom. So you see that a lot of time. The most recent amended trademarks legislation in China actually included bad faith registration as a ground for invalidating a trademark registration, or in preventing one from getting their trademarks registered.
Well, thank you. Thank you. This was a lengthy answer. It was really good, really in detail. Let's say if I have intention to, let's say, open franchises in China. So when is a good time to register trademarks, logos, and everything? What is a good time?
Oh, you have to do it immediately. So because in China, it's a first to file system, it's not a first to use system. And because you have a true intent in using that trademark in association with certain goods and services, then I would say you have to file immediately. Right? I'd like to give you an, okay, maybe I'll give you a case. You all know Michael Jordan, right? The basketball player. Yeah. There was a long litigation, like it's over 8 years, and it comprised of 80 different lawsuits and countersuits, okay, over 8 years. And it's with respect to the mark called Jordan, Jordan.
Okay.
Actually, no, it's Qiaodan, Qiaodan. That's a transliteration of Jordan in Chinese, in Mandarin. Qiaodan. Okay. So at that time, Michael Jordan hasn't registered his trademark in China, the word Qiaodan. And there was a company called Qiaodan Sports that registered probably around 200 different trademarks, okay, in China, and it also includes Qiaodan. Okay, but he did not. That company did not register the mark in bad faith. It actually used the trademark and sell a lot of goods in the years 2000 and so, all throughout the decades, and it actually set up 6,000 different shops in China too, and selling their goods. So it's valid use of the trademark Qiaodan. And so later on, and then eventually later on, Nike obtained rights from Michael Jordan in using the name Michael Jordan. And at that time, Nike is only, using the mark to do manufacturing in China, but not selling to China, not selling to consumers. If you recall, quite a years back, because manufacturing is quite cheap in China, a lot of the foreign countries, outsource their manufacturing to China.
Right.
And the goods are not sold in China, but actually have them manufactured there and then sold back to, to the West. Right. And so, but then later on, Nike realized that Chinese has a big market, and it has a lot of, consumers that can afford to buy a lot of luxury goods and things like that. So it then planned to file trademark applications and register the word Qiaodan or Jordan, and then it was refused by the trademarks office in China, saying that it's confusingly similar to Qiaodan Sports Qiaodan. Okay, so that's what happened. If you, even though and to cut this story short, what I'm trying to say is that if you know or intend to use a particular trademark in China or anywhere else, register right away. So
that would, sorry. So that would include registering the English name and the possible translation in that language.
Transliteration, Pinyin transliteration, right? How it sounds, Pinyin, transliteration. It's always a good idea. And sometimes people also register its Chinese character too, depending on how you want to use it. But one thing is that you have to remember that if you don't, like once you have your mark registered, and if you don't use it within 3 years, then somebody else could launch an expungement proceeding against you to cancel your mark. So that's a possibility.
So what kind of usage are you talking about? Can I just do something really minor to prove that I've actually used it?
Yeah, you can. Well, as long as it's used in trade, so you're selling things in the market and things like that, right? And the other thing is you may not even need to do it yourself, because, for example, like in Canada here, you can, let's say, for example, if I am a Chinese registrant, I'm based in China, and I registered a mark in Canada. And once it's registered, I can actually license my registered trademark to somebody else in Canada to use.
Okay.
And that use is counted as your use, as the owner's.
Oh, okay.
In that case, you will be okay. So, you don't need to worry about the non-use requirement.
Okay. So based on my knowledge, which is an old knowledge, that if I register a worldwide a WIPO, that doesn't include China. I have to do it again in China. Am I correct, or?
No. Okay. No. Okay. So there's no such thing as international trademark, although it's confusing. There's a term called international trademark registration, and that's a trademark registration obtained when you filed under Madrid Protocol, which is an international treaty administered by WIPO, or World Intellectual Property Office. What that does is that you file one single trademark application, and you can designate all the countries that are parties to Madrid Protocol. Okay, so you only need to file one application. And then once you file that application, you can then, the WIPO will then forward it to the trademark office of the designated intellectual property offices in the jurisdictions that you want. And they will examine them according to their local rules. Okay, but one thing though is that there is a requirement that you, wherever you are at, so say for example, right now, assuming that you're in Canada, then you need to file a Canadian trademark application first.
Okay, yeah, I'm in Vancouver.
File a Madrid Protocol application.
I see.
China is part of Madrid Protocol. So if you file
okay.
Madrid Protocol, you can designate China as one of the countries. But Yeah, but there are some strategic concerns or issues that sometimes a trademark lawyer or IP lawyer would advise you to follow a certain filing strategy rather than using Madrid protocol for all jurisdictions, because for Madrid protocol they have something called central attack. So if a trademark is registered and because the Madrid protocol application is based on your home trademark registration, right? So if that trademark registration is canceled within the first 5 years, then all the other trademark registrations all over the world will be canceled as well. So that's what we call the central attack. So there are different things that you would need to consider.
So Amelia, is there any field of IP law that you don't practice, or you do everything?
I don't file patents, but I do patent opinion and patent infringement and validity opinion and everything else except for filing patents applications in Canada.
Thanks, Amelia. I think I better leave some time for other members. Yeah, thank you. Appreciate it. Yeah.
You're welcome. I see Winston.
Thank you. Winston, yeah.
Hey, Amelia, it was a very good presentation.
Thank you, Winston.
So I just want to discuss a few issues with you. I really don't have a specific question. So the first thing I could think of is, as an IP lawyer, do you practice only in Canada, or do you also cover China?
Yeah, very good question. So for lawyers, we are licensed only in whichever jurisdiction you where you got your license. So in my case, I'm licensed in Canada, so I can only practice law in Canada. However, my firm has a network, a strategic network of global network of strategic partners. Of IP professionals all over the world. So for example, for my clients, when they come to me and want to say register their trademarks in Canada, I always have that discussions with them, and because they eventually would want to file, to file trademarks elsewhere as well, because now they're selling goods everywhere, right? So so in that case, I will advise my clients and also be sort of act as the one-stop shop for my clients, and I will then provide instruction on behalf of my clients and interface with the IP lawyers in other countries. And it's the IP lawyers or IP agents in the other countries who will be filing those trademark applications or patent applications, etc., etc.
Okay, so actually, just to extend the question a little bit, or the issue a little bit more. Now, you know, those issues that you present mainly covers Canada.
Yes.
Specifically Canada.
That's
now,
right.
if you look at China, do they have almost similar rules and regulations, or are they so different that someone who wants to go into China really has to engage a China IP lawyer?
Yes. So each country has their own laws, and they are different. There are many areas that are quite common across the board, but there are specific things that are very unique to each country. So if you would be, say, for example, if you really want to enforce or sue someone in China, for example, you must engage a Chinese lawyer.
Mm-hmm.
Okay. Now, because a lot of my clients are also Canadians or English speaking, they can't quite understand Chinese, right? And also, they basically retain me as their one-stop shop, where I interface with all the different lawyers from different countries. So especially in the past, now I no longer do patent prosecution or patent applications, but in the early days, I do patent applications as well. So, for example, BlackBerry was one of my clients in the past, right? And so when we file patent applications, for example, they would want to file in other countries as well. Now, a lot of times it's good for you to have one IP lawyer overseeing everything, because the way you respond to examiners' objections could be similar. You don't want to have a contradicting response.
Yeah, that makes sense to me.
Mhm.
Because, you know, especially like take for example, Nike, you don't want to present a different answer to in Korea, South Korea versus, let's say, in China.
That's right. That's right. That's right. Exactly. Mhm.
So another issue that I was thinking about is, and you probably have already covered that, how big is the IP business in terms of, you know, the IP attorneys? What are we talking about in terms of all the firms' revenue? Let's say in Canada versus the world, is that a big business?
Now, if you look at it, for example, in Canada, if you like the charts that I've shown a while ago, right? So you get a little bit of an appreciation in terms of where the heavyweights are. So most of the people are filings in China, Asia, US. So the biggest ones are US, China, US, Korea, Japan, and European Union. Okay, at least those are the places where Canadian applicants want to register their IPs in. Okay, and so in that case, they retain us, the Canadian IP professionals. We then work with the IP professionals in all those jurisdictions in getting the IP registered for our clients here in Canada. So that's one thing. The other thing that we do is we actually file or register the IP rights here in Canada. And so there are, so for example, like trademarks, 50% of US trademark filings come to Canada, right? So those have to be processed by Canadian trademark agents here.
Okay, all right. That's all from me.
Mhm.
Thank you.
Thank you.
I can ask a question. It costs something, even though it is necessary to do all the IP related care and protection and all that. It costs some money. How big a business before they actually will spend a lot of time into this?
You know what? Well, myself, I have been working with small, medium-sized enterprises for quite a while. I represented Canada in the Presidential Task Force for SMEs and Entrepreneurship at the International Trademark Association. And I've been working a lot with the SMEs here. Basically, the one thing is that you have to think about IP as soon as you think about your business strategy, because IP is time sensitive. If you don't consider your IP in the early days, you may forfeit your rights to even get your IP registered. And aside from that, sometimes it's not you, sometimes it's other people who may sue you, right? So if you don't have your IPs protected, you will become a victim. Right? And registering, like getting a trademark registered and copyright registered or whatever, and even a patent registered, it's considerably much cheaper than being engaged in a lawsuit, right? If somebody else sue you. And
So it's like a life.
Mm-hmm.
So it's like a life and death for the business, even
Yes.
from day one.
Yes, Yes, it is. Yeah, exactly. Like, I may not be very clear, but in one of the slides when I show Madrid Protocol, wherein if you, let's say, for example, if you have been operating your business here in Canada for many years already, and you have not registered your trademark in Canada, somebody else outside of Canada may be able to file a trademark application here in Canada and get their mark registered before you, right? And eventually you may potentially even lose your rights.
And when that happens, what do people think about those people? Do they think that they're very smart, or do they think that really bad?
In terms of what? Who they?
The people who try to steal other people's
Oh,
IP.
okay, all right. Well, see, first of all, the stealing, it's of course it's a bad thing, because now under our amended trademark law here in Canada, which is effective June 17, 2019, we also have bad faith as a ground to invalidate another's registration. But the problem is, if, say, for example, if I have been using a mark here in Canada for many years, and then somebody else, but I haven't registered my trademark here, and then somebody else actually registered the mark ahead of me, and it's actually using it as well. Maybe he's in Vancouver and I'm in Ottawa and I'm not aware of it, right? So once this mark is registered for 5 years, then I will have no option. I will basically have no rights to cancel his trademark.
Okay, Amelia, thank you for the interesting talk. I do have one comment, also one question. The comment is from your lawyer, you said that we should try to register your IP right as soon as possible.
Yes.
But for a small company or startup, the cost is really the concern. You know, for example, in America, I mean, a lot of people, they don't want to go to legal action for justice because the cost is really discourage people to take legal actions. Okay, I mean, we have to get a balance, okay? From your lawyer view, from your viewpoint, probably you think that you should do it as soon as possible. But it all depends, okay? This is my comment. The question is, if there are disputes on the IP rights for about trademarks, I mean, for example, some people may, even to register it, I may modify a little bit, okay? So that you can, well, some of the color, you know, I change a little bit. The domain name, I can use an O instead of a 0. Okay, I can use a capital I instead of L. I mean, I can still register and get around, you know. So how do you handle this thing? And how do there's a dispute on that thing? I mean, you go to a dispute court or something like this. I mean, how would you handle this? And can you comment on that?
Yeah, sure. Now, for startups and small and medium-sized enterprises, cost is always a concern, right? But at the same time, we have to understand that for a business, the intangible assets worth a lot. If you spend a lot of time in building your business, but ended up your brand that you've built over the years are taken away by other people, such that you can no longer use it, or let's say, for example, if somebody has been, there's too many marks that are very similar to yours operating in the market, and it's in association with similar goods, then your mark might be diluted such that people wouldn't recognize, your mark will not stand out. Okay, and there may be even depreciation of goodwill if somebody else did something bad on a very similar mark, on a mark that is very similar to yours, right? So you have to take that into account. So if you're building a business, you want it to go well and you want it to be successful. It's like an investment. But if you think of registration of these IP rights, it's not expensive. Well, relatively speaking, like even for a copyright, for example, it's less than $1,000, right? It's only a few $100s. For a trademark, it's usually like 1,000 some, you know, I would say you reserve, I would tell people to budget between $2,000 to $3,000 or $5,000, depending on how complicated the case is, right? So, but if it's a smooth case, you can even get your trademark registered with you know, anything below $2,000. So if you think about that, it's really nothing compared to you know, to the business that you're building over time. If you like, I remember this one time when Apple, for example, tried to get into the Chinese market. It's called iPad, right? iPad, iPhone, iPad. So it bought the iPad trademark, but they didn't know. Yeah, and well, anyways, it wanted to enter into the Chinese market, but then the iPad trademark actually belonged to somebody else. Okay, so eventually they have to, you know, it has to pay, if I remember correctly, it's around $6.3 million or something. And at the same time, there's an injunction, i.e. all the iPads have to be taken off the shelf, right? So as you can see, like if it would have registered, like do a trademark search and file and register its trademark, it may cost Apple at that time probably less than a couple of $1,000, as opposed to, you know, the $6.3 million of lawsuits and you know, and taking all its iPads off the shelf. Right, so it's a balancing thing that we have to consider.
Yeah. Hi.
A question from Colin.
Colin?
Hi, Amelia. Enjoy your, yeah, from Hong Kong. I enjoy your talk. Have a very quick question. We license a technology from Canada and proceed to build a $150 million processing plant in China. As we start up and operating the plant, we improve the technology. And so we want to file additional patent. Do we need to start applying from the China side, or this is, you know, related patent improvement to the original licensed patent, or should we proceed simultaneously in Canada and China at the same time?
Okay. Yeah, so I won't be answering specific question, but let me answer you in a general way. So first of all, it depends on number one, the terms in your license agreement. As to any improvements to the license technology, who will be owning that, right? Is it the licensee or is it the licensor? That's one thing that you need to look at. Okay. Now, assuming that I don't know, you are the licensor or licensee? You're the
licensee.
You're the
Canadian company is the original owner of the license.
Right. So first of all, you would need to look at the terms in your license agreement to see who owns the new improvements, you know, on top of those patented technologies, right? Is it the licensee or is it the licensor? So look at your contract. Second thing is depending on where those improvements were made. If it's made in China, then you must and have no choice but to file in China first. Each country is different, and that's why there's something called foreign filing license, okay, for patents. And each country is different. So a while ago, for example, I mentioned about in Canada, for example, we have I don't know if I've mentioned that, but in Canada, we have a grace period of 12 months for an inventor to file a patent application in Canada once he himself disclosed the invention to the public. Okay, and that's why you may see some people, you know, quickly file their patent applications before they publish their inventions in a journal or before they go to you know, international conferences, and that's one of the reasons why. But in China, there's absolute novelty, meaning to say once it's disclosed, then you cannot file in China. Now, there is some very strict circumstances wherein there's an exception that provides you with a 6-month grace period in China. But back to your question relating to the improvements that were made, if it's made in China, then you have to file in China first.
Thank you.
You're welcome.
Yeah.
I have a question.
Mhm.
So we have the physical world, and if we do a good job, you know, the IP is protected in the real world. And you mentioned about the metaverse, the
Yeah.
virtual world. So again, we will need protection on the virtual world as well. And you gave us some examples of some big name companies are already doing it. In the virtual world, is it like there will be one work, one task, and you cover all, or is really a total unknown? I mean, if there are 10 universe, you have to go to 10 universe to do your IP protection.
No. No. So, okay, so the actual IP protection is done by trademark, say, for example, trademark. It's done, you do your trademark registration here in the real world, okay? Now, when you file a trademark application, aside from providing, you have to include, of course, the trademark, the mark on the application. You also have to specify the list of goods and services that you intend to use with the trademark. Okay, now when I talked about metaverse a while ago, now, for example, if I say I want to use ABC as a trademark, and the goods are clothings, okay, clothings, for example, those are real clothings in the physical world. Now, what the big brands are doing now is that they extend their application or file new applications and added additional goods on their list of goods and services, saying virtual clothings or downloadable clothings, something of that sort. Okay, so they just added another unit, another goods and services on their application or registration.
Okay, they just need to add the word downloadable, almost.
Well, there's more that you can say. Yeah, it's almost, yeah. Yeah.
Okay, a question from Francis Chin.
Yeah, hello. I'm actually Beth, Francis's wife, and I just want to follow up on that question about the cost. I understand that if you were caught in some sort of litigation, obviously it would cost a lot more than having initially registered your IP or trademark or whatever. But I just want to answer the cost that you quote seems not too much. Okay, so I was wondering, does that include all geographic locations? I mean, I heard that it sort of adds up when you take do filings on IP or patents. You have each region is different, and then you add up in quite a bit. So I was wondering about that. And also, I've discussed, with Francis about, registering trademark, and of course he's against it. And I was wondering that if for certain types of business, it makes a lot of sense if you have a brand that you've built up, or you're building a brand that is like a B2C situation. But if it's, not that kind of situation, is there, any advice about when to do your trademark? And if you're
definitely. Yeah, so I'll give you a few examples. Like, for example, my understanding is in, for example, if it's in Canada, like Amazon, if you're planning to sell your goods in Amazon, you must have your trademark registered. And similarly, if you want to use the Alibaba, I think, and all those Chinese e-commerce platform, they also required trademark registration as well. And actually, there are, because always I fully appreciate and understand, for smaller companies, because I've been working with a lot of them. There are ways where you can enforce your IP rights you know, with low cost or no cost at all, right? So say, for example, if you're using some of those e-commerce platforms like Alibaba's or Amazon, they do have a way for you to file complaint online yourself.
Yeah.
Right, and what they'll do is that as long as you have, and typically you will need to provide them with your trademark registration or copyright registration, which shows your ownership, and then they will take down the sites. Right, so that's an example of some, you know, cheaper ways of enforcing your rights.
Okay,
Yeah,
thank you.
But you know, like a lot of times we don't only think about, okay, so when we talk about losses, you know, oh, it's very expensive, which is very true. But at the same time, if you don't have any weapons yourself, if you don't have a trademark yourself, you have no rights yourself, then you'll be in a poorer situation, right? But if you have your rights registered, people will have to think twice before they infringe on your mark.
Thank you. We have just a few more minutes to go.
And also the other thing is that you really need to monitor, like today I was only able to really talk about registration or different types of IPs. But aside from that, you also have to monitor, because remember, like intangible assets is like almost 90% of your business value, right? So if you know, if you're willing to buy insurance for your house, you would want to do the same thing for your intangible assets too, right? And once you have it registered, that's just the very first step, or the minimum that you need to do. Next is to monitor the market and also enforce it. And sometimes enforcing it is not as scary as you think. I have several clients wherein they found confusingly similar trademark, and obviously those people are riding, like getting a free ride. They want to build on the goodwill of my client's brand. Okay, so they use a slightly different but very confusingly similar trademark, and so my client want to enforce against that infringer. But when you think about enforcement, you think about lawsuits, which is expensive, right? But there are ways wherein it may not. For example, usually what I do is that I'll write a cease and desist letter to the other party, to the alleged infringing party, okay, warning them. And a lot of times, you know, they will just go away and abide. So basically in my cease and desist letter, I will give them maybe 1 week or 2 weeks time to take down all their infringing goods or logos and everything else, right? And in the letter, I will also say that my client wants to solve this amicably, friendly, without getting into lawsuit. But you must, you know, remove all the infringing logos within a week or so. And if you don't, then we reserve our right in taking legal actions. And a lot of times that may scare the other party out, and they will just take, you know, remove their infringing logos, and the case end there, just end there.
Thank you. Now, while everybody is thinking about the final question, maybe I ask a more personal question. I realize that you lived in many parts of the world, Amelia, and you lived in Vancouver, you live in Ottawa. Can you tell us your feelings or comparison between the two cities?
Well, Vancouver is very nice, but it's very, very nice. I like the mild weather at that time. I don't know about now with the climate change, but there's a lot of gray rainy days as well in Vancouver, but I love the people there and I love the food there and everything. In Ottawa, it's a very small city compared to Vancouver. You have everything here, but it's really small and cozy. So I think I'm used to Ottawa now, except for the cold. It's minus 25 or 27 right now.
Wow.
Yeah, I guess like
Okay, we are 6 degree in Richmond now. 6 degree in Richmond.
very nice, very nice.
I would like to share experience what one of my friends' business in China. In fact, he's trying to the one who try to enforce the trademark. He's hired by those brand name, for example, LV and all these brand name articles. And what his job is just to go to this to find out, okay, who's violating their trademarks, and try to not suing them, but try to warn them, okay? If not, they will take action, you know, from the line, you know, from the police.
Yeah, public
security.
security.
You know.
Mm-hmm. Right. Yes, that's right.
Private investigator, you know, they are hired by a lot of brand name people.
That's right, exactly. So there's a lot of things going on in China, and private investigator definitely is one thing. And a lot of times, like I mentioned, for example, like in Canada, I mentioned about customs recordal, which is an option for all the registered trademark owners as well as for registered copyright owners. You just need to file something called a request for assistance to the customs, and the customs officer will stop any shipments that has that infringing logos or whatever that infringes on your IP rights, and will notify you. And in China, for example, their customs has been doing a very good job. And they have stopped many shipments, and they work very closely with Alibaba and other e-commerce platforms as well. And even the brand owners will have to educate the customs officers so that they'll be able to distinguish, counterfeits, for example, so that the customs officer will be able to notify the brand owners once there's some, suspicious infringing goods that came into China.
Okay, we are closing the Q&A session now, and we have the closing remark from Michael, some announcements.
Yes, thank you, Amelia. 大家好，多謝你今日嚟幫我哋解釋咗好多 question， 同埋介紹咗呢個 trademark pattern 嘅事。我有個 personal question 問你 ：With your talent in English, Mandarin, and Cantonese, would you be better off to stay in China?
Will I what? Or will I prefer? Is it your question?
That's my question. Yes. My
China.
Oh, okay. I am a very global person. At this point in time, I would love to stay in China. I grew up in Hong Kong, Philippines, and then I live in Vancouver and Ottawa, and right now in China, I think there are a lot of excitement going on there. And last time when I went, I went to China several times, and I find the people to be very, very warm and friendly. And in terms of work, I think there's a lot of excitement there. So I don't mind living in China or in Hong Kong or in Canada. I think all are nice.
Hello, Amelia.
Hi.
Hello. Hi, Amelia. I wonder if you can remember a guy whose name is Ian Chen, who met you in 1998. Together, we joined a trade mission of HKCBA, Hong Kong Canada Business Association. We met in Hong Kong.
Right. Yes. Hi, Ian. How are you?
Yeah, I'm good. We have a nice chat at the well on the I forgot the name喂大會堂叫
南丫島啊，我哋去南丫島食海鮮。
係啊係。
I was sitting next to you.
That's right, Michael.
And yes, yeah, we are at the same table.
Yeah. Well, actually, that's in 2000 and it's 2000 and
Yes.
something. Yeah.
Yeah.
Late
It
2000.
was hosted by the Hong Kong Canadian Business Associations.
Yes, that's right.
Yes.
Yeah. At that time, when we met, I was one of the owner of a small electronic factory. So we talk a lot about IP and trademark because we have some item we need your services. But eventually I immigrated into Canada and I'm now doing a cabinet factory here. And next time you are welcome to come to our factory. We have some quite new design.
Okay, great.
Right?
Looking
In
forward
Vancouver.
to it.
You just call
Michael.
Yeah, he's my buddy. So he can find me anytime, anywhere.
Yes.
Good. Small world.
Yes.
Yes. 我亦都想喺個群裏邊講咧 ，Hong Kong Canadian Business Association 咧，每年都有一個 trade show， 有一個 trade delegation 咧去香港嘅。咁啊，Ian會長咧就好多時咧都帶埋好多啲朋友過去嘅。咁如果即係疫情好轉之後咧，我相信咧我哋會再搞翻呢個 trade mission 咧，亦都睇下邊啲有朋友有興趣嘅話咧，我哋可以一齊參加嘅。不過就要早啲報名啦，同阿鄭會長報名得㗎啦。OK， 咁嗱，而家咧就主持咧已經宣布咗散會㗎啦。咁我哋可以留低繼續講嘢，但係咧我有一個聲明咧，就話下個禮拜係咩精彩節目？下個禮拜咧，我哋就由阿 Charles 就講下關於呢個中國嘅房地產嘅走勢咁之前咧，我同阿 Charles 亦都講過一輯咧，就係關於呢個恒大啦。咁恒大事件嚟講咧，而家已經即係開始有啲苗頭啦，有啲開始落幕啦。咁但係咧，就中國亦都有新嘅政策，關於即係希望咧每一個人都有屋住啲講到明咧，啲屋就要嚟住，就唔係要嚟炒嘅。咁所以阿 Charles 咧就會喺將呢個問題上面咧，就同大家解釋，就會介紹同大家講下即係中國而家呢個房地產嘅趨勢，同埋假如你喺中國有屋嘅話咧，啲房地產會唔會跌咧，還是會繼續升咧？咁呢個咧，我哋留翻下一次Charles同我哋講啦。咁我要宣佈嘅完咗啦。
係Michael，我驚我忘記啫，老人家啦已經。我想問一下，如果我哋去 China 買房地產，到最終會有一日我哋要賣噶嘛？如果我哋賣翻出嚟，嗰個外匯想攞翻過嚟，即係話中國外匯管制呢個問題點搞咧？
嗱，我哋呢度咧唔講呢啲 personal 嘅嘢啦，咁我哋 close 咗我哋嘅個seminar 先，咁然後即邊位願意留低傾下閒偈嘅話，可以繼續討論呢個問題。
都唔係 personal 啦，好多張嚟。Steven
交翻俾你。
係。
咁如果大家要做其他 activity 嘅咧，就請可以自己leave 嗰個 meeting 啦。咁Michael 話齋，如果其他朋友好難見到面，想問下對方啲傾下嘢咁樣，可以留低多一陣間啦。或者 Vincent， 我哋留低幾耐好啊？如果傾閒偈。
冇 limit 㗎，不過咧而家我咧就。